assault on Israel. The NYPD says anti-Semitic crimes accounted for more than half of the hate crimes that took place in the city last month. Anti-Semitism has been on the rise. This is SRN News. Mississippi's health department says Jackson's water is safe.
The announcement Friday came one day after health officials told residents in the state's capital dangerous bacteria could be in their tap water. The health advisory was lifted after a new round of tests did not find E. coli in the city's supply, reversing the department's Thursday instructions for Jackson residents to boil their water before consuming it.
That's Ron DeRockstra. Good news from Delta Airlines.
The airline says it closed 2023 strong and expects another good year in 2024. Although shares fell because Delta trimmed a forecast for full year 2024 earnings. The airline earned $2 billion in the fourth quarter, and revenue for all of last year was a record. The airline is feeling flush, so it's ordering more planes. Delta says it will buy 20 Airbus A350s for international service and take options to get 20 more. John Scott reporting.
More of these stories at srnnews.com.
The following program is sponsored by the law offices of Patrick L. Smith. This is the Attorney Patrick Smith Show. Get ready with your legal questions and call Patrick now. 877-943-9673. Again, that's 877-943-9673. The law office is open. And now your host, Patrick Smith.
Good morning, Florida. This is Attorney Patrick Smith, and I'm your host of the Attorney Patrick Smith Show. We will be with you live for the next hour to answer all of your legal questions. 877-943-9673 to be part of today's live and local show. A very special welcome to all our new listeners out there. For those of you new to the program, this is a legal call-in show, and I'm your host and Sherpa to your guide for more legal knowledge. So you can call us now with your legal questions, and I will give you the very best legal answer we can live over the air every Saturday morning, 8 to 9 a.m. That number, 877-943-9673. You can also always email me directly, Patrick at attorneypatricksmith.com. Lots of you do. We're always happy to oblige and get your response via email to each and every one of your emails. That's Patrick at attorneypatricksmith.com. Let's jump right into it. Where we left off last week, I think it was a caller named Julian, who was our last caller of the show, and he made a request basically saying, can you give me some examples of any application of Section 3 of the 14th Amendment? Okay, so for those of you who didn't hear last week's show, just a brief recap so you kind of be caught up with the rest of us. We talked at length about the decisions facing the Supreme Court of the United States regarding President Trump and whether or not he is disqualified from service according to Section 3 of the 14th Amendment. So for those of you, again, who did not hear last week's show, we're all about education here at the Attorney Patrick Smith Show. So we're going to go to the primary source. For those of you not familiar with that particular provision of our Constitution, here it is. No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. Now, we're going to come back to that here in a few moments. So, for those of you who are taking notes, those three elements, insurrection, rebellion, or giving any aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. So just to go back to the primary source, that is the clause that we are discussing. And last week we sort of teed it up, kind of where the court could go with sort of a determination that President Trump is ineligible, and that settles it. President Trump is eligible to be on the ballot, or some kind of hybrid decision in between. And stay tuned when the Supreme Court decision comes down. Of course, we will be reporting it to you here on the Attorney Patrick Smith Show. But as a follow-up piece to that, and to get to Julian's point about examples, first, a little more background, and then I promise the examples of the application. But first, a little more framework. According to ABC News, there's a fantastic article that came out, and it came out earlier, or actually late 2023, this article came out, and it goes into a deep dive on sort of the framers' intent when they structured the 14th Amendment of the United States Constitution, specifically Section 3. So if you have a question on this, you can go ahead and hop in the queue if you want to talk to us about it this morning, 877-943-9673. Again, that toll-free number, if you have a thought, comment on Section 3 of the 14th Amendment of the United States, 877-943-9673. All right, so the article says, the intent of the 14th Amendment's disqualification clause is central to the debate over whether former President Donald Trump's name should be stricken from GOP primary ballots now that the issue has landed at the steps of the Supreme Court. This is what we told you last week. Judges and officials across many states around the country are now grappling with language that was written a year after the end of the Civil War. So putting things in perspective here, this is not recent. The words insurrection and rebellion, I told you we were going to come back to that. We'll do a deep dive into that here a little bit from now. The words insurrection and rebellion had certain meanings to those who had them added to the Constitution. And a key question for arbiters now is whether the language drafted a century and a half ago should apply to Trump's role in the January 6th riots. As it originally passed the House, the 14th Amendment's third section was not nearly as broad as the version now being invoked to strike Trump's name from the ballot. It was narrowly crafted to apply only to those who willingly took part in the Civil War, and it was only meant to deprive former Confederates of their rights to cast ballots in federal elections. It also had an expiration date. Section 3 of the 14th Amendment was valid until the 4th day of July in the year 1870. All persons who voluntarily adhered to the late insurrection, giving it aid and comfort, shall be excluded from the right to vote for representatives in Congress or for electors and president and vice president of the United States. The original House version read according to the congressional records of the era. So you see it had a different feel to it. Then it had this termination date. The Senate spent several days debating the House-passed amendment in the spring of 1866. While the birthright citizenship provision in Section 1 earned a lot of time in the debate, Section 3 was also the subject of an intense back and forth on the floor. The transcripts can be read in the Congressional Globe, a forerunner to the Congressional Record. Here are the key senators at play in the actual formation of Section 3 of the 14th Amendment. Senator Jacob Howard of Michigan, who led the Republicans in debate, according to ABC News, insisted that it wouldn't be enough to deprive the former Confederates of their right to vote in federal elections. He wanted them banished from government service altogether. According to ABC News, again, quoting Senator Howard, I should prefer a clause prohibiting all persons who have participated in the rebellion and who were over 21 or 25 years of age, rather, at the breaking of the rebellion, from all participation in office, either federal or state, throughout the United States. A senator goes on to say, I think such provision would be a benefit to the nation. After about a week of discussions with colleagues, Howard offered Section 3 language that was ultimately ratified. Howard's revision removed specific references to the rebellion and added an important qualifier. Those who were to be excluded from government service would have to have violated oaths to defend the Constitution by having engaged in insurrection or rebellion or given aid or comfort to the enemy. That's that key language. And that's really the trigger for Section 3. And we'll talk here in a moment about what triggers those. What is insurrection? What is rebellion? What is giving aid or comfort to the enemies? Senators rejected various attempts to reinsert the word voluntarily or to restrict the exclusion of those who violated their oaths during the time they were still serving in office. There was a great deal of concern voiced in debate that Howard's exclusion clause might leave the South ungovernable. Basically, why? Well, if you're excluding everyone, who's going to hold office was basically the concern. Nevertheless, the version Howard introduced made it through the entire ratification process and actually became law on July 9th, 1868. In 2024, the originalists of the Supreme Court will likely seek to determine whether the ratifiers have had it in mind 158 years ago that Section 3 might not only be applied to late insurrection as the House passed version originally had it, but also to any other rebellion that might later take place. But originalists might take note of what Senator Peter Van Winkle of West Virginia said as he sought to have the threshold of congressional amnesty lowered from the simple majority rather than 2/3. That's that last provision where who's disqualified can actually have that removed. That disqualification can be resolved. This Senator Peter Van Winkle of West Virginia, was advocating for a simple majority rather than what ultimately became the law, 2/3. Senator Van Winkle says this is to go into our Constitution and to stand to govern future insurrection as well as the present. And I should like to have that point definitely understood. It's worth noting that there was just a single reference to the Senate debate to the fact that the president and vice president were not explicitly mentioned, because this is what the Trump campaign keeps advocating, whether or not this clause even applies to the president. In Howard's draft, as officer of the United States, the way members of Congress and state officials have been itemized in the text. Would the disqualification clause of the amendment not cover the top post of the executive branch? ABC News asked. Why did you omit to exclude them? Asked Maryland Democratic Senator Reverdy Johnson. And Maine's Lost Memorial jumped in to clarify by saying, quote, "Let me call the senator's attention to the words, or hold any office, civil or military, under the United States," Morrill said, ending the discussion at that point. So basically the conclusion of that article saying, look, at the time, if you look at the actual congressional debate, some of the senators were definitely thinking that this would have a broader application beyond the post-Civil War world, and that it would have an application to the president of the United States. So if you have any thoughts whether or not that it's an appropriate application or not, 877-943-9673, 877-943-9673. And Nate, the intern, doing a great job this week with some wonderful research on examples of when Section 3 of the 14th Amendment has been used. Congress, the most recent example was Congress last used Section 3, and this is according to Congressional Record Services, last used Section 3 of the 14th Amendment in 1919, so over 100 years ago, to deny seating a socialist congressman accused of giving aid and comfort to Germany during the First World War, irrespective of the Amnesty Act. That was an act removing political disabilities imposed by the 14th Amendment. The actual congressman was named Victor Berger, and he was the first socialist member of Congress. And by the way, he was eventually seated in Congress in a subsequent Congress after the Supreme Court threw out his espionage conviction. And there was another gentleman as well. That particular gentleman, but this was earlier than Mr. Berger. This actually goes back to the Civil War. This gentleman's name is John D. Young. After the Civil War, during a hearing to determine whether John D. Young provided aid and comfort to the Confederacy and therefore was ineligible to be seated in the House of Representatives, the Committee of Elections was of the opinion that aid and comfort may be given to an enemy by words of encouragement or the expression of opinion from one occupying an influential position. So it appears the aid and comfort's the most popular one here being used to actually disqualify someone from office. We really don't see the rebellion or insurrection very much. Those, by the way, according to Congressional Record Services, define terms. So according to Congressional Record Services, we have some guidance there. Insurrection is actually defined in the Insurrection Act and basically described as it's basically talking about the president's ability to respond. So the president has the ability under the Insurrection Act to call up the militia and armed forces in the event of unlawful obstructions, combinations, or assemblages or rebellion against the authority of the United States that make it impracticable to enforce the laws of the United States. So basically, that is a great way to back in to sort of what insurrection means by addressing what the president's trigger is to sort of raise those militias. And so there's a deep dive with some examples per Julian's request last week of the application of the 14th Amendment Section 3 clause to disqualify a political candidate. And I love constitutional law, but that was a lot of constitutional law, guys. So if you have a question on it, 877-943-9673 or any other legal question, you're welcome to call in. We're happy to help you any way we can. This is the Attorney Patrick Smith Show, and I'm Attorney Patrick Smith, and we're here every Saturday to give you the best legal advice that we can. That toll-free number we're standing by, open studio lines, will get you and your question right on the air. 877-943-9673. Give us a call now, and we'll be happy to help you as best we can. And I will give out the office line. Before I do, I want to send out some very special thank yous. Had a couple of great seminars this past week. We actually had two back-to-back. My first time in 17 years of law practice having back-to-back seminars, and it was it was invigorating. It was kind of like a doubleheader in baseball. It was just straight into the next one, and it was fantastic. But it was only because of the energy of the crowds that I was able to get through both of those back to back. So a very special thank you to everyone who turned out at both Kings Ridge and Highland Ridge. They were very complimentary at Highland Ridge. The management staff there is telling me that this was the largest crowd they've ever seen for anyone who's shown up to host an event there at Highland Ridge. So if you happen to need a speaker, you can reach out to me directly at the office. And it's the same office number you call to get your complimentary consultation. So same number, 877-754-6764. That's your toll-free office line, Monday through Friday. The offices in Claremont, Clearwater, Sarasota, Sun City Center, all those office locations, one phone line to call and schedule your appointment, 877-754-6764. Again, you can call Monday through Friday. Any friendly member of our staff will be happy to help you get that appointment scheduled or book us to come out and speak to your club or group. And speaking of speaking engagements, those of you in the Indian Rocks Beach area, we will be live and in person Wednesday night there at Indian Rocks Beach doing our typical presentation on wills and trusts, taking your questions and answers at the end. And had a fantastic question and answer session yesterday because we actually had a retired attorney in the audience, and it was absolutely invigorating to get sort of those levels of questions. And I feel like the entire listening audience that day benefited from having that experienced retired attorney in the audience. So a very special thank you to him for turning out. But if you want to meet us in person and hear our presentation this Wednesday, Indian Rocks Baptist Church, sponsored by the Indian Rocks Foundation, and that is Wednesday, 6:30 p.m. And it's going to be in the Education Center, room 267. So room 267. If you need more information on this, you can reach out to my office line, and our staff will make sure you get directions and know where to go and when to be there. Again, that office line, 877-754-6764. That's reminding me of the time years ago when I was just sort of asleep at the wheel giving out a number, and I gave out my home line just for whatever reason. And someone called it, and my wife answered and said, he's doing his radio show right now. And I said, boy, I really ought not to fall asleep at the mic because apparently I give out my home line when I do. So the office line, if you want to get more information on that speaking engagement, book us to come and speak to your club or group or book your complimentary consultation, 877-754-6764. To talk to us today, 877-943-9673. This is the Attorney Patrick Smith Show, and we're going to go talk to Dave. Dave, welcome to the Attorney Patrick Smith Show.
How's it going?
Good, Dave. How's Sarasota?
It's a little, wet today. It rained last night.
Yeah, it's chilly too. I had to make sure to dress a little warmer than I normally do. So what can we do for you, Dave?
I had a goofy question, but maybe not. My question is, when Ron DeSantis was running for his position that he has in the state of Florida, and he went and told everybody he wasn't going to run for president, is there a way to look into how much money he has spent on him running for president and using the state's money for that purpose? Or is there any conversation being had related to that? Because it's interesting that he's been stuck in a state, with the caucuses for I don't know how long now. I saw a thing on the TV. He did 167 appearances in that area. When is he doing things here now? How does that work, sir?
I don't know is the short answer, but it's interesting because we're actually lining up with the Iowa caucuses happening next week, we're actually lining up some special guests to potentially talk about those exact issues and kind of what that's going to look like for the governor, depending on what the outcome is from the Iowa caucuses. So, Dave, I guess the best answer I can give you is I'm sure all the campaign financing, I think there's publication of that, so you have to track that and report it. And there's certainly legislation that governs the appropriate use of campaign funds and the list of. And I don't know that the governor has ever been accused of doing anything inappropriate in any way, but there's certainly a long list of other candidates that have, and them being caught and prosecuted accordingly. So I don't think the governor's doing anything wrong. I think that would have been discovered and reported by now. But as far as to answer your specific question, as far as what category which expenses fall into, we're going to have some special guests next week, I think, that might be able to speak directly to that.
Am I there?
You're here.
Okay. I thought my audio got cut out for a second. No, well, the thing I would say is more the time, like his physical time that I would be interested to see, like, physically when he's supposed to be governing and when he's supposed to be doing other things, and that actual amount of time spent. Like that's what I'm curious of. And I had a quick question related to your production. Did you hire Hoppy for your phone screener?
I did not hire anyone.
I think you have Hoppy, who used to formerly work for The Bone, as your phone screener now, possibly.
Yeah.
It's not a bad thing.
Yeah, no, but I did not hire anyone. So to be clear, that decision, it's Salem. It was not my personal decision.
It's Salem? Hoppy's in Salem?
You're hearing it here.
Right on.
Dave, anything else?
No, great show.
All right, Dave, we appreciate you calling in.
Yeah, stay warm, stay dry.
Thank you. Alrighty, 877-943-9673, 877-943-9673 to give us a call now to be part of today's show. Yeah, we do have some special guests and things that we're trying to line up, sort of put a bow on the first week of primaries. Of course, from a legal perspective, we're not a political show. I don't want to get into the politics of it. So if you want to prime for next week, write the number down again and call us next week with all your questions about sort of the legal fallout from the Iowa caucuses, 877-943-9673. Plus, we may have a new Supreme Court decision by then regarding the Section 3 14th Amendment application, which we started off the show discussing. 877-943-9673. That's to be part of the Attorney Patrick Smith Show. I'm Attorney Patrick Smith, and we are live on the air taking your questions. Next, we're going to go to Lake Placid, and we're going to talk to Michael. Michael.
943-9673, 877-943-9673.
Hey, Michael.
Just calling out, be part of today's show. Yeah,
Michael.
We do have some special guests and things that we're trying to line up.
This is what happens, folks, when people don't turn down their radios. Michael, can you hear me? Can you turn down your radio, Michael?
If you want to prime for next week, write the number down. You can call us.
We're almost there. He's about caught up with his lives. Michael, can you hear us?
No.
Michael,
Can't hardly hear you at all.
you got to turn down your radio, brother.
It's already down.
All right. Michael, how can we help you?
I was wanting to make a comment on as far as Trump being able to run for president. I do not think so. In my mind, from just looking at everything that he's done, he did support the insurrection. They say, oh, it wasn't an insurrection, it was a protest. It was not a protest. When you try to take over a government building, and that is an insurrection. Everything that goes wrong is somebody else's fault in his mind. If he don't win, they cheated. It just on and on and on. They've already started it this year. That if the Republicans don't win, they've cheated. That the Democrats have cheated.
All right. So, Michael,
I don't understand it. I don't see it. I don't understand the people that go behind and back him. I don't understand it at all.
By whom was it?
It doesn't matter.
Michael, by whom was it determined that former President Trump had committed the acts of insurrection? By whom was that adjudicated?
I am sorry, I cannot hear you. So I gave my opinion. It's about all I could do. Thank you.
All right. I don't know. Maybe you guys checked the audio. I don't know what the issue was there. So my follow-up to Michael was, he said, President Trump was involved in the insurrection. Was that adjudicated in a court? Was there due process to that? I mean, in some of these other cases, like we talked about with, with Mr. Berger, there was espionage charges that were litigated in open court, and ultimately those charges were dismissed and overturned. At what point was President Trump litigated and charged in some capacity for insurrection or rebellion or aiding? And my only point being, there's been no formal adjudication. It's sort of this arbitrary determination by state representatives that they believe this. Well, is that proper application of Section 3 of the 14th Amendment? I'm not so sure it is. So I'm just saying, from a legal perspective, I'm not so sure we can just jump to this conclusion. I think that deserves, for the sake of our country, for future use of this, not just in the President Trump scenario, I don't think we can just say, yeah, someone did that without properly adjudicating whether or not that is true. So, but yeah, Michael, I wish you could have heard us, and I would have loved to have gone back and forth with you a little more. 877-943-9673. If you have a thought for today's show or a question, we're happy to help. 877-943-9673. I'm attorney Patrick Smith. Brian, welcome to the Attorney Patrick Smith Show.
Hey, Mr. Smith, how you doing, sir?
I'm great, Brian. How can we help you today?
I wanted to see if you have any expertise in employment law by chance.
No. That was an easy question, Brian. Any others?
Do you know somebody I could call?
Sure. Yeah. Give us a call at the office next week, and I'll put you in touch with 2 or 3 employment attorneys. You want to go ahead and tell us your question in case one's listening? By the way, if you're listening to and you hear Brian's labor law question, you're an employment attorney, I'm giving you permission. Call in, and I'll let you answer Brian's question live on the air. So, Brian, in case there is a labor law or employment law attorney listening, go ahead with your question.
Well, it may sound petty, but there's a lot of backstory to the circumstance. I was terminated before the end of the year. I held a status with the company of a highly compensated employee, and they cut me loose approximately 3 weeks before I was going to be fully vested in the company. We're a publicly traded company that I worked for on the NYCE, and I had a handful of different little bit of harassment kind of issues going on because of my compensation at work, and there's been a handful of things that have come to light since my exit of nepotism, etc. That's now coming into that location. So it's something that would be a little bit difficult to get fully involved with on air. But
yeah, you don't have to get into the detail on the air, Brian. That's okay. And even though I'm not, I don't hold myself out as an employment attorney. I'm certainly not. I'm definitely a wills and trust guy. And actually, I've been recognized as such. I'm going to get into that. We actually had a fan of the show write a song about me, Brian. Can you believe that?
I can.
Yeah. So I'm going to read the song here. And I reached out. They sent me the lyrics. We don't have the music. But I'm going to read the lyrics here momentarily. But anyway, the short answer to your question, did you have an employment contract with your employer?
I did, but I also had a non-compete as well.
Yep. So you're going to live and die by what we call the Four Corners Doctrine there. That's just contract law. The words on that page are going to say whether or not they did something that violated the contract or whether or not they acted within the terms of the contract. So have that contract handy. So when you call me at the office and I refer you to a good employment law attorney, the first thing they're going to ask for, what do you think it is, Brian?
My non-compete.
Yep. They want to, well, not just the non-compete, they want to see the entire contract. So are you telling me the entire agreement you have is just the non-compete, or you actually have an employment contract coupled with a non-compete?
No, I basically had a non-compete agreement. That was the only terms, and I signed it 11 years ago. The address is at a location that we are not at anymore, and basically the officer who signed it has not been with the company for 10 years. Yeah,
I don't know if that's going to affect the non-compete so much. Typically, the things that
Probably
affect
not.
the non-competes are what we call and I have done a show on non-compete clauses, and it's basically a reasonableness test, and its reasonableness is to the length of time of the non-compete and sort of the geographic scope of the non-compete. And, usually most of them say it's this area, And I think the presumed reasonable period is anything less than 2 years. So that's sort of the standard if memory serves correctly. But have that handy. It sounds like you were an employee at will. So they probably could terminate you for any reason at any time. Any reason that doesn't violate law, obviously. So more than likely, that's the scenario. You're an employee at will who happen to have a non-compete clause. But get that non-compete clause handy and give me a call next week. I'll put you in touch with an employment law attorney who can tell you whether or not you have anything worth pursuing.
Awesome. I appreciate it.
No problem, Brian. Have a great weekend, okay?
You too. Thank you.
Yes, sir. All righty, 877-943-9673. That's your live and local toll-free number to be part of the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith Show, and also recent subject of the newest song I've ever heard of. So yeah, actually a fan yesterday morning reached out and sent me the lyrics to a song that they have written in my honor. By the way, if you want to be part of today's show, that number, toll-free, open studio lines, 877-943-9673, 877-943-9673. That's your live and local number to be part of today's show. Give us a call now, 877-943-9673. So anyway, and I've reached out to the fan. I reached out to the fan that wrote the lyrics, and I said, hey, where's the music, the melody that goes with this? I have every intent of making certain that this song becomes a fully produced song. We're going to perform it, not perform it. We're going to play it for you live here on the show. Nevertheless, lest I keep you in suspense about the details of the lyrics any longer, I will now, in a very poetry reading style, perform a dramatic reading of the lyrics. It's untitled, by the way. There's no title to this, so I don't know what the title is. I don't know what the melody sounds like. Nevertheless, here we go. Verse 1. In the heart of Florida, where the sun paints the sky, Patrick Smith, an attorney, reaches high. Born in Polk County, with dreams to unfold, an estate planning maestro, his story told. Oh, Patrick Smith, guiding legacies with care, in Florida's embrace, a legal flair. From Polk's roots to estates he attends, a planner of future where wisdom transcends. With wills and trust like seeds he sows, in the soil of guidance, knowledge he bestows. Florida's counselor in matters of the estate, Patrick Smith, where expertise creates. Oh, Patrick Smith, guiding legacies with care, in Florida's embrace, a legal flair. From Polk's roots to estates he attends, a planner of futures where wisdom transcends. Through probate's path and assets wide, Patrick navigates with expertise as his guide. In the realm of planning, where wishes take flight, he crafts legacies with insight so bright. From Polk County's birth to estates he frames, Patrick orchestrates with legal aims. In Florida's tapestry, a planner's decree, weaving futures where legacies are free. Oh, Patrick Smith, guiding legacies with care, in Florida's embrace, a legal flair. From Polk's roots to estates he attends, a planner of future where wisdom transcends. To Claremont, the maestro of estate planning's art, in Florida's realm, he plays a vital part. Born in Polk County, with a vision so grand, guiding legacies with an expert's hand. That is the entire song, and I sent that. So I sent that not only to Joe Weaver, who instantly said, "That's oh my gosh, that's a real song." I sent it to Mo, and I said, "Mo, I mean, goodness gracious, you're creative," and Mo said, "That's a real song." And so now we have the lyrics to a song about me, and my ego's at an all-time high right now, having written a song about me, and yeah, we have to get the lyrics put with music, and we're going to produce this thing, and we'll play it for you live here on the air. So I am blown away by the listenership out there and the level of appreciation you guys have for the show. So thank you for this, for the lyrics to a song about me. And we were trying to decide, we didn't want to jump to conclusions about sort of the melody of the song. And at first I thought maybe it had kind of a a little bit of a rock and roll feel to it. And then I thought, no, maybe it's more like an acoustic guitar kind of. And I thought, because it's sort of like about one person, about me, and the first song that popped in my head was like Big Bad John, like sort of that, fabled storytelling vibe to it. So stay tuned for what actually comes out of this, and we'll play it for you here live on the show. 877-943-9673. That's your live and local number to be part of today's show. We'd love to talk to you today. Any legal question, fair game. Give us a call now. Open studio lines. We'll get you right on the air. 877-943-9673. You can always email your questions too, by the way, Patrick at attorneypatricksmith.com. And lots of you do that. The emails always flood in. We don't have time to get to, we don't really get to many of them on the air because I'm usually dealing with calls. 877-943-9673, your number to be part of today's show. I do want to give a special shout out and teaser for Model Senate. I had a very invigorating meeting this week regarding Model Senate, which is coming up March 21st through the 23rd over at Stetson University. And we were talking about the speakers we're lining up. Some very, very exciting speakers have been confirmed. So we'll do a formal announcement a little closer to the event, but very excited about this year's speakers and looking forward to another successful Model Senate. For those of you not familiar with Model Senate, the Model Senate program is sponsored by Stetson University, and we are proud to put that event on. Both my wife and I financially support this event, and this event basically hosts students from all around the country in a 3-day long competition portraying U.S. senators, and they participate in Senate floor debate, Senate hearings, Senate committee meetings, and actually portray the senator and compete for different awards and prizes. But I refer to it as sort of the incubator of democracy, where, tomorrow's legislators sort of practice in a scenario where they can't actually harm anyone if they mess up too badly, and hopefully preparing them to go out and be real legislators someday. And we actually have our first recent Model Senate participant who is currently running for state office. So we're very excited about that as well. So stay tuned for more on that. But make sure you look up Stetson's Model Senate, especially if you have, and by the way, they've expanded the rules now. Not only undergrads are eligible, but they're actually reserving a certain number of spots for high school seniors. So if you have a high school senior that's politically minded and would like to participate in this competition, that's the big news breaking this week. The powers that be at Stetson University have opened up a few spots for any high school senior who's seeking to participate in the 52nd annual Model Senate. So if you want more information about that, you can always reach out to my office directly. Again, that office line, 877-754-6764. I was a 4-time participant in Model Senate, and I will tell you right now, I've never had so much fun. Maybe as much fun as I had when I attended Boys State. That was a blast as well. But participating in these model government programs, always a great time. And it definitely gives you a level of appreciation for what the real legislatures deal with on a daily basis, as far as the workload and the stress and the need to find compromise for pushing legislation through. So it's a challenging job, but it's an eye-opening experience. And if you have an undergraduate level student or a high school senior who would be interested in politically minded practice, the Model Senate program would be perfect for them. So to reach out to the office for more information, 877-754-6764. To talk to us today, though, that toll-free number, 877-943-9673, 877-943-9673. And yes, someone asked, yes, we are still taking intern applications. So if you're interested in interning for me, we would be happy to take a look at your application and try to find a spot for you here working at the practice. So if you want more information about that, you can email me directly, send your resume, patrick@attorneypatricksmith.com, patrick@attorneypatricksmith.com. But to be part of today's show, 877-943-9673. So I want to go back to an interaction I actually had yesterday at Highland Ridge, my second presentation of the day in beautiful Claremont, Florida. And someone asked me and said, I see your rates for the trust. And it was a married couple. And he said, I understand you do the trust for $695. And he said, I presume that's $695 for myself and $695 for my wife. I said, no, that's for the couple. They were doing the same plan. And he said, why are you so much more affordable compared to what I was quoted elsewhere? And I said, I can't comment on why other people charge what they charge. I can only tell you why I charge what I charge. And here's my philosophy on that. Here's what I told them. I said, look, I think estate planning is so important that everyone needs it at some level. You know, not everyone needs a trust. Some people need wills, and some people need complex or advanced trust planning. But for me, my philosophy has always been, I don't want anyone denied access to estate planning because they can't afford it. So my philosophy has been, when I set my rates at $75 for wills and $6.95 for a trust package, the logic being ideally that people of those financial levels requiring those plans can hopefully easily afford that. And that way it makes it affordable. So the families that need that planning get it, or at least the reason they're not getting it is not because they can't afford it. So that's been my model. And they seem to appreciate that. But I thought I'd share that with you because a lot of people ask me regularly, they say, why are your rates published? And why are they what they are? And that's my reason, and that's my rationale. So we're proud to do that and provide the flat fee estate planning. And a lot of people like it because, we tell you out of the gate what it's going to cost start to finish and put it in a written fee agreement. And that way everyone is on the same page. And, with it being a flat fee, if you call 10 times a day, every day with questions, not that I'm encouraging that, but I'm saying if you did, the fee's not affected. So it encourages attorney-client communication, in my opinion, because of the fact that, it's a flat fee. You're not paying any extra to call with questions. If you want to call with a question now, 877-943-9673. You can actually see all of our fees for our services. They're available at the website, attorneypatricksmith.com. That's also another way to book your appointment. So if you have the need for an estate planning consultation, or you need a referral to an attorney of a different practice area, you can reach out directly to me through the website, attorneypatricksmith.com. That's also where you can go back and listen to archive shows. If you want to go back and listen to any of our previous broadcasts on different topics, maybe listen more slowly to our presentations on homestead, sort of pause, take notes, and make some follow-up points. You can go back and listen on demand anytime, attorneypatricksmith.com. Just scroll down to the radio link to be part of today's show, 877-943-9673, 877-943-9673. And very special thank you to everyone who supported and appreciated the presentation on the Corporate Transparency Act that we started the show with last week. Again, a special thank you to my beautiful wife, Christy, for suggesting that topic. She was the muse that led me to doing that presentation. But if you ever have an idea for the show, I'm not so proud that I'm above taking suggestions from listeners and clients by any means. It's an open forum as far as suggestions for topics. I have fraternity brothers and friends and clients and regular listeners to the show that I've never even met sending me suggested topics to discuss. So you are welcome to do so as well. And you can do so by emailing me. That's probably the best way if you're going to send a suggested show prep idea. That would be patrick@attorneypatricksmith.com. And I'll be happy to do what we can to try to get that topic on the air. 877-943-9673 to be part of today's show. 877-943. I'm still blown away by the song. It's so good. I got this and I can't stop reading it because the level, and Joe Weaver was saying the same thing when I was sharing it with him. He's like, someone put a lot of effort into that. And I'm just extremely flattered by the song. So yeah, if you want to ask a question about the song, I got it right here. We can answer any of your questions about the lyrics. 877-943-9673. 877-943-9673. All right, let's go to Eric in Sarasota. Eric, welcome to the Attorney Patrick Smith Show.
Good morning. I had the pleasure of meeting with you for a review of our revocable living trust. And I really appreciated that. It was very useful for my wife and myself. But just recently, a question came up, or an issue came up. I went to the local branch of a bank here and to rent a safe deposit box. And I wanted to set it up in the name of the Revocable Living Trust. But they kind of insisted if I wanted to have my wife and myself, who are the primary trustees, to have access to the account but also have our daughters have access to that safe. We cannot set it up in the name of the trust, but should set it up in the name of where all individuals, all four of us, could sign. Is that the best advice I got?
Well, so here's the thing. First of all, Eric, I appreciate your kind words. Thank you for that. That means a lot to me. So I appreciate your kind words about our interaction. The bank didn't give you wrong advice. You can put a safe deposit box in all four names, but here's the distinction. Okay, so having it, and it may not be a big deal to you, but for some families, this will be a very big deal. So if you put it in all four names individually, yours, your wife's, and your daughter's, that means your daughters now can walk in off the street and empty whatever's in that box. You may be a dad with a relationship with his daughters where you're like, yeah, that's good. I'm not worried about them doing that. But some parents out there would be. So the safeguard against that would be to have it in the trust so that daughters, as I presume, do you mind answering live on the air, Eric? Are your daughters your successor trustees?
Yes.
So in that particular situation, if the box were held in the name of the trust, your daughters would only have access to the box upon your death or incapacity. So with that being the structure, it's really a matter of your preferences. If you want them to have access only under those circumstances, your death or incapacity, go and insist that it be put in the trust. Otherwise, if you're okay with it being in all four names and them having direct access to everything now, you can leave it the way they suggested.
But I understand that part. But how would it work if I want our daughters, with whom we have a great relationship, and how would that impact a potential probate? How would that safe be handled in a probate case?
Neither scenario, I don't think, would wind up in probate. Of course, the trust avoids probate because of the fact that it's a living entity owned by you, and living trust to living beneficiary, by definition, avoids probate. The other scenario is, remember, the definition of probate is the court supervised transfer of assets from a deceased person's name, and really it should say a deceased person's name only, to the appropriate living beneficiary. This asset doesn't meet that definition's requirements, Eric, because if it's an asset owned by you and your wife and daughter one and daughter two, when you die, is it in just your name? No. So it's not a probate asset, in my opinion.
Okay, so going along with the suggestion of the bank to have the safe deposit box in the name of all four of us would be okay and would not incur probate issues for us.
Yeah, I don't see how it would on these facts. I think it really comes down to your comfort level with having the girls with direct access now, while you and your wife are both healthy and of sound mind, being able to go in there. If you're okay with that, I think you go with the bank employee's advice. If you're not okay with that for some reason, or if things change down the road where you're not okay with that, I think you go in and insist that they put it in the name of the trust.
Thank you so much for your advice.
All righty, Eric, I appreciate it. And thank you again for your kind words. You have a great Saturday, okay?
Same to you.
All right,
Bye-bye.
bye-bye. All righty, you're listening to the Attorney Patrick Smith Show. 877-943-9673. That's your live and local number for next week's program. We will very likely be doing something about the Iowa caucuses or any new legal developments. I'm really hoping we get a Supreme Court decision on Section 3 of the 14th Amendment, most notably because that way we can put a bow on this and move on. And we've done a deep dive, but I definitely like to keep it light in a show immediately following a deep constitutional dive. I remember trying to come up with something fun and interesting at the same time, right after we did the Roe versus Wade, the Dodd decision, and the 4 shows we did on that. So we'll try to come up with something a little more lighthearted for next week after doing a sort of more complex and cerebral show on constitutional law the last 2 Saturdays. 877-943-9673. That's your live and local number. Don't forget, if you're in the Indian Rocks Beach area this Wednesday night, 6:30 p.m., I will be speaking at Indian Rocks Baptist Church, sponsored and hosted by the Indian Rocks Foundation. A very special thank you to them for having me out yet again. I love speaking at Indian Rocks Baptist Church and look forward to that. That will be in the Education Center, room 267, Wednesday evening, 6:30 p.m. I will be live in person presenting and taking your questions. And if you want to book me to come out and speak to your group or book your private consultation with me regarding your estate planning, that number at the office, 877-754-6764. Again, that toll-free office line, 877-754-6764. 888-848-9464. Everyone stay safe. God bless. Have a fantastic weekend, and we'll talk to you next week.